Morning to this event dedicated to undue use of judicial actions against journalists and activists. We will consider some European prospects on that topic. My name is Theodor Stoichev, and I'm head of the European Parliament Liaison Office in Sofia. I'm sure that this event today will be most interesting and appealing to numerous people, different audiences, because the first panel will be dedicated to the European Framework for Protection of Journalists and Civil Society Activists against lapse, and the second panel will look into the Bulgarian perspective on that topic. And now let me introduce today's moderator, Maria Cheresheva, who is representing the Association of European Journalists. Good morning from Sofia. Greetings to our international participants. My name is Maria, and I'm a journalist. Just like many other journalists, I have been subject of judicial actions and could be considered slaps. We tend to call them not only as an abbreviation, slap with double P, but also the other word that is slap on the face. Journalists cannot be silenced. On the other hand, every person has the right of proper and well-conducted court proceedings. Without subjecting to be put under pressure. But the case with journalists is different. Many such litigations cause lots of resources and personal defamation. So we have gathered here panelists at a very high level, including from Bulgaria, in order to bring clarity what exactly are slaps and what is the European response to them. Some technical details, some administrative issues. You may raise your questions in the Zoom function, and also those that are following in Facebook, in the Facebook page of the European Parliament Liaison Office in Sofia. We can do our best in order to make sure all your questions are heard and responded. You may ask your questions live instead of writing, but just raise your hand. Use the raised function. I'm sorry, I lost the sound. And now I will switch into English, simply because the first panel is organized only by international participants. So please use the interpretation function if you need to hear the interpretation.
The problem with the slaps. Our panelists are Tiemo Wölken, member of the European Parliament from the ACD group and co-rapporteur on the topic. Luise Quaritsch, legal and policy assistant in the DG Justice of the European Commission. Julie Majerczak, head of the Brussels office of Reporters Without Borders. And Jessica Ní Mhainín, Policy and Campaigns Manager in Index on Censorship, another press group that is really heavily working on the problem with strategic lawsuits against public participation. I will start with the news that maybe not all of us know. is that in the recent weeks, as Theodore said, the European Parliament adopted a report which is calling, it's opening the initiative to launch European legislation which is treating the problem with strategic lawsuits against public participation. The European Commission since October has opened consultations in which all the interest groups can participate. So in the next year, basically, we are expecting these discussions to take real shape in the form of legislation. My first question here will be to Mr. Wölken. Could you please let us know more about your report, which you did together with Roberta Metsola, another MEP, and what did you find out, and what are your main recommendations to the European Commission?
Yes, I'm happy to answer this. First of all, thank you very much for the invitation. And this event is indeed very timely, as the Parliament just a couple of weeks ago voted with a very large majority in favor of our proposal for an anti-SLAPP initiative report. Unfortunately, we are seeing indeed a rise of numbers of SLAPPs within the European Union, with cases in almost all member states. So during the preparation of the initiative report, the co-rapporteur, Roberta Metsola, and myself, we had indeed the chance to speak to many affected journalists, NGOs, and human rights activists. So this is the reason we actively have to work for an anti-SLAPP directive in combination with soft law measures. So something we as Parliament are now calling for. So binding law and additional measures. So explicitly, we are asking for a directive in order to get minimum standards within the Union on the one hand, and giving member states on the other hand the freedom to go beyond what we are asking for to increase the standards. So we need a clear EU-wide definition of SLAPPs. We don't have it yet, so this is what we are asking for, including the definition of public participation on a matter of public interest. So this is crucial for defining a SLAPP lawsuit. So this will be the basis for everyone to know if a case is a SLAPP case or not. What we want additionally is, for example, a reversed burden of proof, where the claimant has to show that his or her case is not a SLAPP case. So we are asking for an early dismissal mechanism that could be based on objective criteria, such as the number and nature of lawsuits or actions brought by the claimant, the choice of jurisdiction and law applicable to the case, or the existence of a clear and burdensome imbalance of power between the claimant and the defendant. So the directive should, moreover, include effective remedies for defendants who report breaches of union law or reveal information in the public interest, and additionally address a proscribed forum shopping. So limiting the possibility, and you mentioned it, for the selection of jurisdiction in which to prosecute defendants in SLAPP cases to their country of residence. And additionally, as I mentioned, soft law measures are also very important, like adequate training of judges and lawyers in order to contribute to the knowledge and capacity building and how to detect and deal with SLAPPs. SLAPP victims need effective assistance, information, and practical advice and support. And that is why we are asking for a one-stop shop, so a support hub strengthened by dedicated national networks and specialized lawyers. We want to see legal, so where SLAPP victims really can get the support they need. So you can see this as a kind of legal first aid, yeah, and financial and psychological support, because SLAPP cases are very expensive, and of course they force people really to spend a lot of time to think only about it. So it's a really psychological burden. So we have to provide the best possible support system. And coming to an end, as the only directly elected EU institution. The Parliament is here to represent and to help our citizens. And this includes being the voice of those who are being wronged, like SLAPP victims. And we will do our best to push the European Commission and the member states to achieve this goal of adopting anti-SLAPP legislation. And if you allow me one last sentence regarding to the new German government, as the new chancellor is in parallel elected at the moment. In the coalition agreement, the new government in Germany committed to fight against SLAPPs. So SLAPPs made it to the new coalition agreement. And I hope that this will be the case in many other member states too. We can't hear you, sorry. We don't hear you.
Can you hear me now? Okay, sorry, we had a small technical problem. So the main issue, one of the main issues is that actually in no member state there is already introduced a SLAPP legislation. So it's great that the European institutions are taking measures, but it's also good for some countries to lead the process. And my next question will be to Madam Quaritsch from the European Commission, because the ball is now in the European Commission. Please, could you please let us know what are the next steps and what is currently going on in the Commission legislative initiative so that we can have this legislation fact maybe next year?
Yes. As you mentioned, the Commission is currently working on an initiative to protect journalists, but not only journalists, but also rights defenders against SLAPP. And as was mentioned already, this has been identified as a matter of serious concern. It has been mentioned in the rule of law reports in some member states. And what we have found so far is that the most effective way to tackle this issue would probably be a combination of legislative and non-legislative measures. Concerning the legislative measures, we are looking at targeted legislation and procedural safeguards against SLAPP in cross-border civil proceedings. And this would be complemented by non-legislative measures that would cover aspects such as the training of legal professionals on SLAPP, awareness raising on SLAPP, and monitoring of the phenomenon more broadly in the EU. As you mentioned, there are some broader efforts under the European Democracy Action Plan and some other initiatives to protect journalists in the EU. For example, the Commission already adopted a recommendation on the protection, safety, and empowerment of journalists quite recently. And you might have also heard of the European Media Freedom Act that is supposed to be, or in the planning for 2022. And but I think it's noteworthy that the SLAPP initiative will go beyond that a little bit, in that it also tackles or includes right defenders and anyone that's working on matters of public interest. Right now, we are in the evidence gathering phase, and we have found that it is a quite complex and diverse issue that takes different forms in different member states. And as you mentioned, in October, we opened the open public consultation, and it will still be open until the 10th of January. So I would invite all participants to submit their input on this, whether it's as an association or even as a citizen, so that we can really gather all the evidence that we have to ensure that we find the most effective possible solution for this at EU level.
Is this consultation also open to journalists who can share their experience and cases with you?
Yes, it's open to everybody.
You will find more information about this open consultation on the pages of the European Commission, I think also in the Parliament, so feel free to do it. I'm sure that this would be very useful for the Commission. So just to make another clarification, we are most probably expecting separate legislation from the Media Freedom Act. Did I get it right?
Yes, that will be a separate piece of legislation.
Okay. Now I'll give the floor to Julie Majerczak, head of the Brussels office of Reporters Without Borders. Hi, Julie. Sorry, today all the names are quite difficult to pronounce as a native Bulgarian. My question for you would be, as you heard from our previous speakers, is that there is no general definition of the term slap. I'm sure that there are journalists who have been slapped but have no idea about it. Could you please explain to us how Reporters Without Borders would define that, and really how big is the problem in the European Union? Are we witnessing an increase of slaps, or we just started talking about them?
Yes, hi. Thanks for the invitation, and no worry with my name. It's quite hard to pronounce, and I'm used to it, so you can just call me Julie. It's fine.
Thank you.
So yes, I mean, over the last few years, we have noticed a significant rise in legal harassment in the EU. More and more journalists, but also media, are being subject to abusive lawsuits, and these gag lawsuits are used to silence them, to silence these media and journalists that hold those in position of power to account. And when Maltese journalist Daphne Caruana Galizia was assassinated in October 2017, she had 47 lawsuits pending against her. And they were intended to intimidate her, to strangle her financially, and ultimately to silence her. And at that time, a lot of press freedom organizations realized with this case, with this horrific case, that slap were a growing problem. And as Tiemo Wölken said, it's true that now we can see it in almost every country in the EU. So it means that journalists and media, we depend on for information about what is happening around us, are being distracted, are being impeded, or even entirely blocked from pursuing their work by these costly and resource-intensive legal attacks. And we realize also that it was not only a problem for journalists and media, but also for activists, trade unionists, academics, researchers, human rights defenders. And yet this scrutiny, holding people to account, holding people who have the power to account, this scrutiny is the lifeblood of healthy democratic society. And when we consider the importance of public watchdogs, such as investigative journalists, activists, and whistleblowers to the rule of law and the fight against corruption, this absence of safeguards is a threat not only to press freedom, but also to the proper function of the European Union, and increasingly to Europe's democratic life. That's why we started to advocate for EU measure measures, anti-slap measures at the EU level. And in June 2019, 119 NGOs, including Greenpeace, Transparency International, Index of Censorship, the European Federation of Journalists, we co-signed a policy paper calling for EU anti-slap measures. And the fact that more than 100 NGOs and organizations signed this policy paper proved that this increasing development of slap is a threat, as I said, to media freedom, public interest, and beyond to the democracy and that it needs to be addressed at the EU level. I'm going to go now to your second question, which was about what is a slap and how we can define it. So it's true that there is not a clear definition, but as I said, I use different words, synonym. It's a kind of legal harassment. It's an abusive lawsuit. What we can see usually in SLAP is that the purpose, is not to win. The purpose is to let me see, because is to it's to threat journalists or activists. And sometimes, the lawsuit is sometimes just the tip of the iceberg. A lot of time, just a letter is enough to silence journalists. So it has a very strong chilling effect and also self-censorship. So, who
are the people who and the institutions maybe who most often use this legal harassment against free speech?
Yeah, well, I'm just going to be a bit more precise about what is a SLAP. So we also, with I think 60 organizations after this policy paper, we ask some legal experts to draft a model directive. So it's a very solid work. And the way we think SLAP should be defined is not really, a definition, but it's the core element of a SLAP. And it's usually characterized by the identification of the behavior from which the claim arises as public participation on a matter of public interest, the limited prospects of success of the claim, normally due to its unfounded and excessive, unreasonable nature, and third, the use of the judicial process having regard to the scope and nature of the claim of the litigation tactic deployed for purpose other than of it genuinely asserting, vindicating, or exerting a right, but rather than of intimidating, depleting, or exhausting the resources of the target with the ultimate aim of dissuading the behavior at the origin of the claim or other forms of public participation. So that gives you an idea that it is possible not to give, a very strict definition, but to be able to identify what is a SLAP.
I'm sure that this is a challenge for the judges, but it's of course not something impossible. And I will give the floor to Jessica. Index on Censorship is another organization which is monitoring and giving raising awareness about all these cases in Europe. Maybe you could tell us a bit more about some of the cases that you have worked on. You've published a number of reports recently.
Thanks a lot, Maria. And we're so appreciative for you hosting this discussion today, which we feel is so important for raising awareness about SLAPs, which I think is one of the main reasons that we can actually tackle them. And if you'll allow me as well, I'll actually pick up a little bit where Julie left off regarding how we identify SLAPs, which I think which I'll use as well to bring in some examples, and hopefully this will help illuminate the issue for any journalists in the audience, that if they're maybe facing a lawsuit and they're wondering, is this a SLAP? It will maybe help them as well. So as we've heard from all of our panelists, holding power to account is one of the cornerstones of democracy. But as you can tell, SLAPs are putting our fundamental right to impart and receive information, and therefore also our democracies, at risk. As you said, Maria, my organization, Index on Censorship, started working on slaps 2 years ago. And at that stage, we started contacting journalists across Europe and trying to encourage them to share their experiences of facing slaps with us. It was, and it is still, surprisingly challenging to get journalists to speak about their experience of facing slaps due to the level of fear and intimidation they quite often feel. We would really encourage journalists and other public watchdogs not to allow themselves to be silenced by slaps. We need them, their trust and their support in order to stop slaps. And so if anyone here today feels that they might be facing a slap, please do be in touch with us, as there is support available. So as I say, how do you know if you're facing a slap? As has been said, there's no strict definition, but we very often use like a series of symptoms that are kind of typical in many slap cases. So here I'm going to name 5. Firstly, and this is probably the most important symptom, there tends to be an inequality of arms between the plaintiff and the defendant. The defendant might be a small media outlet or an individual journalist, an individual campaigner or an academic, while the plaintiff will most likely be a very wealthy or powerful individual. To give an example, in the UK, journalist and author Catherine Belton is facing defamation lawsuits from Russian billionaire Roman Abramovich, who is the owner of Chelsea Football Club. 5 lawsuits were initially filed against Belton and her publisher, including from Rosneft, which is a state oil company in Russia. And those were in relation to claims she put in her book, her excellent book, by the way, which I highly recommend, Putin's People. So secondly, that's the first symptom. Secondly, the plaintiff will very often try to exacerbate this inequality by pursuing disproportionately large amount of compensation from the defendant. Again, to give an example, in Estonia, 2 journalists who work for the public service broadcaster there are currently being sued as individuals, not their company, by a Finnish businessman for €1 billion. And that's, as I say, that's as individuals. So this puts their personal property, their homes on the line. It means that they need to put them up and risk losing that potentially. So again, this is used to really increase the intimidation that the journalists feel. So thirdly, the speech in question, so the speech that is the subject of the lawsuit, will tend to be on a matter of public interest. For example, regarding corruption or financial crime involving a public official. Again, to give an example, well, of a British journalist, but of a lawsuit that is happening in the EU. So British journalist Oliver Bullough is currently being sued in Portugal by the Vice President of Angola for more than €500,000 because he raised questions in his book, Moneyland, about how the Vice President of Angola could have afforded to spend $200,000 on custom-made bridal wear for his daughter. And by the way, that shopping spree was actually featured on the US television show Say Yes to the Dress. I don't know how well that's known in Bulgaria, but there's been different, iterations of that television program around the world. So it wasn't exactly a secret. They put it on television. And when this journalist wrote about it, he got a lawsuit. This is some of the strange, very often these lawsuits tend to be strange and not also have a lot of logic to them. And I think that that particular lawsuit shows that. So the fourth symptom is lawsuits or legal threats are very often based on defamation law, though an increasing number of lawsuits invoke other laws as well, such as privacy and data protection. And fifth and finally, the plaintiffs very often have a history of legal intimidation, and they may use the same law firms to facilitate slaps. Especially, as I say, in the UK and I think in France as well, there's particular law firms that basically specialize in intimidating journalists. So I think that's another issue related to this that we need to focus on. So why have slaps been rising in recent years? I think that this is happening in a broader context. I think slaps are rising in the back with, for instance, in the background, rising inequality and the collapse of funding models for media outlets. When slaps were first identified in the 1980s, there was around 140 billionaires in the world. Now there are more than 3,000 billionaires in the world. So this is really helping to fund, to fuel an industry that is intent on shrouding power and wealth in opacity. They're intent in hiding information about their wealth and power from the general public.
So you mean that there is kind of this judicial pressure industry? So it's not only the the powerful people concerned, but also these companies linked to them, these attorneys, and something that
yes, absolutely. There's law firms, and I say especially in London, we can name them quite easily by now. There's the same names that are constantly coming up, and these lawyers, these extremely expensive lawyers, are profiting on damaging our democracy. So this is something that should make us really mad, of course. They're making money out of hiding information from us. So, I think we need to, we have started and we will continue to name and shame them as well. And then if I can maybe, I'd also like to mention, of course, the funding models. Like this is the funding models for traditional media has also collapsed basically in the last, 10, especially 10 years, but even 20 years. And this means that journalists and media lawyers or journalists and media outlets don't have the same access to lawyers. And if they do face a threat, they will very often, maybe say, well, we don't have the funds to do this. If we actually defend ourselves, sometimes a legal defense, depending on where you are. I think in Bulgaria, it's a little bit less expensive than, for instance, in Western Europe, and particularly in for instance, Ireland. I mean, in Ireland, I believe like 3 days in the court could cost you hundreds of thousands of euro. Just to defend before you even if you're completely right, even if everything you've written is accurate and all you're doing is defending yourselves, it could cost you hundreds of thousands of euro. And that could, in a case of a single journalist or a small media outlet, it could potentially force them to close their doors altogether.
This is one of the main issues. I mean, it's if you don't have a strong support, then you cannot even afford to have this defense. I think one of the main problems that we identified in your contributions is actually the multinational level of this slap industry. So, and one of the criticism against the EU was that actually the European legislation allows for such a type of pressure and extortion to journalists. Mr. Wölken, your opinion on that? I mean, of course, the freedom of movement is one of the main merits of the European Union, but this also creates such type of opportunities, so to call them. So could you please elaborate a bit more on your findings and your recommendations to stop this process, basically?
Yeah, and I will. So this was, I think, partly already discussed and mentioned. So this is the problem of liable tourism. So it really means that the claimant chooses the most favorable jurisdiction for his or herself. So the jurisdiction where he or she thinks has the best chances of dragging the case. So in case of slaps, it is usually the jurisdiction that takes the longest time or has the highest cost, as was already highlighted by Jessica. And there is really an industry here. So, and we need to fight that. Unfortunately, the liable tourism is legal at the moment and currently allowed by applicable private international law rules like the Brussels I and Rome II conventions. So there are indeed many cross-border cases, which is the reason we as the Parliament are calling for reform of Brussels I and Rome II. So both were adopted with a view to provide legal certainty and predictability in cross-border litigation. but not for having the misuse of the system in mind. So in regards to Brussels I, we need to change the rules so that the jurisdiction where the lawsuit is taking place is grounded in the forum of the defendant's domicile. So at home of the journalist or the NGO or the right defender. This will combat forum shopping with different jurisdictions, and Rome II does not include a uniform rule on the determination of the applicable law in defamation and privacy claims. So here again, we need a change to provide the predictable outcomes regarding the applicable law. Of course, this will not be easy. And with the United Kingdom or Great Britain having left the European Union, this will even be more complicated. So also, we have not gotten a signal from the Commission that this will also be tackled. I don't know if Luise is ready to answer or give some insights on that, but it would be great to hear a clarification by the Commission that these two issues are also looked at and maybe addressed. This would be of utmost importance, and that's why we included it in our initiative report.
Madam Quaritch, do you have information so far if the European Commission is looking into these issues precisely? Because maybe they can really be tackled with legal measures. There are other issues that might be better to be addressed with soft measures, but here we're talking about problems that are directly related to the EU law.
Yes, I'm afraid I cannot tell you more than you probably know already on these private international law rules, which is that the potential recast or re-evaluation of the Rome II and the Brussels 1A regulation are not part of this specific initiative, but they are being assessed and they might be re-evaluated at a later stage. So there's already been a legal study on the Rome II regulation published, and there will be another legal study on the Brussels 1A regulation that's going to be published soon. And in this context, I might just add that those are horizontal elements or instruments that of course go a bit beyond the specific elements of SLAP. So their re-evaluation will be, it will not be part of this initiative specifically.
Another detail which is maybe would sound like a legal detail, but here we have a lot of interactions between the legal system and press freedom issues, is the type of litigation. Because in some countries, the Liable is under the civic code, but in other countries, there were criticism that they are still under the penal code. So the European institutions have been called to address this issue as well. Do you have information about that? Are you looking into that?
Sorry, could you rephrase the question?
The type of litigations, because it could be civil lawsuits, but this could also be like a criminal lawsuits. And there are criticisms against some EU countries that the criminal lawsuit option still exists there. So are you also looking into this issue?
Okay. Yes, all relevant aspects are being considered, and the current initiative foresees a legal basis on civil judicial cooperation. So criminal law aspects will be looked into, but there are some doubts regarding the legal basis of including such elements.
I think we can already see how actually complex the issue is, and that the process of addressing it would not require just a single solution. Julie, I know that Reporters Without Borders and other NGOs, as you already mentioned, have been part of these group efforts to address the problem. And could you please tell us a bit more about the problem of the type of litigation, like the criminal lawsuits? I actually read a report where a journalist says that they prefer criminal lawsuits because they're cheaper. And in civil lawsuits, there is no threshold. My question is for Julie.
Yes. Sorry, I had to unmute. Yes, as you said, I mean, there's different. There's a variety of with SLAPPs, but it's mainly defamation lawsuits, and in some countries, I can't remember the number exactly. The number, they are still criminal lawsuit. I must say I'm not an expert on what is better, if it's civil or criminal lawsuits. But what I know is that civil lawsuit can last years and years, and they are really exhausting journalists in time and financially, and it's the purpose, the aim of this of the plaintiff to do that. So that's a real issue, and I think it's very important that the Commission propose some EU measures and to fight this libel tourism and this different situation in the EU. It's true that the international private law and the reform of Rome I and Brussels II are important, but the best way to reform is and to have a legal equal playing field is to have an EU directive with procedural safeguards which apply to all member states. Because why someone is going to another country? It's because, yes, there are no standards, so they are completely different rules, and some are better than others. But if we have EU standards, if we have a minimum safeguards, procedural safeguard, then that will be also a very effective way to avoid this tourism and to give a level playing field to the victim of SLAPP and to give them protection.
And a question to Jessica: do you think that did the Brexit change anything? Actually, UK leaving the EU, did it change anything in relation to its status as like a heaven for SLAPP litigations?
Well, kind of. I mean, it did change a little bit. And again, I mean, I'm also not a legal expert, but from asking legal experts, from what I understand, maybe ironically, is that Brexit actually helped the situation with regards to SLAPPs, because previously there's the law that is in operation on this primarily in the UK is the 2013 Defamation Act. And in that act, there is a clause on jurisdiction. And previously, the jurisdiction extended across the EU so that anyone in the EU could bring a case in the UK. Now, as far as I understand, that is no longer the case. But I mean, it still happens. We still have cases ongoing, I guess, particularly pre-Brexit. And I'm thinking specifically of Swedish journalists. There are two Swedish journalists, their editor and a Swedish media outlet that is currently being sued in London by a Swedish businessman who's based in Monaco. He's suing in the UK, but that came in right before kind of the Brexit, before Brexit, basically. So from what I understand, that wouldn't be so easily done now. So to answer your question, yes, Brexit has made a difference, and most likely for the better.
And one last question for me, because before I pass the floor to the questions from the audience, I call on everybody who is watching us to ask questions in Facebook, in Zoom. I'm receiving them, and we will address them to our speakers. But there is also another side of the problem. In countries with problems with press freedom and with problems with media ethics, there is also a lot of like real defamation going on. I mean, media being used as bullets against people who are, for example, critics of the government, etc., or maybe to some officials who are trying to make a change against the status quo, as we like to say in Bulgaria. So how their interest would also be protected? Because so far we're talking mostly about journalists, about activists, but also there is the other side of the claimants that, of course, need to have their proper right to justice. My question is for Tiemo Wölken.
I'm very sorry. I was a bit distracted by getting my camera back to work. So if you could repeat the question,
I will repeat it.
Great.
These are the risks of this online hybrid communication, of course. My question is for countries such as Bulgaria. We will discuss this more, I think, in the second panel with the Bulgarian experts. There is also a lot of the other side of the story. Many media are used as weapons. Because of their lack of independence, as weapons to attack critics of governments, maybe even to attack business people who are openly criticizing some powerful circles. Also against officials who are trying to make a change. So can we guarantee that also their interest would be protected, their interest to seek justice? Because so far we're focusing on journalists, but there is always the other side of the story.
Of course. So, of course, and I think no one really questions it, there is the right to take legal action against reports, for example, which are wrong and which are stating wrong facts. And of course, this right remains untouched. It's a fundamental right, and it's very important. But what we are suggesting as a solution is that at a very early stage of the legal proceeding, there could be the argument by the defendant that this is a slap claim. And in this case, the burden of proof changes, and the claimant has to provide proof that this isn't a slap. And I think it's reasonable and very helpful, because everything Jessica and Julie already mentioned is happening, and slaps are a real threat and a real burden. But of course, we leave the right untouched to defend yourself if there are wrong reports in the world stating wrong facts, and if there are things which aren't accurate. And this is absolutely important, that this right stays intact and stays available. And the other dimension of the question you just mentioned is that there is indeed media which isn't independent. And this is indeed a problem. And so it's important that we do not consider a journalist or a media outlet automatically as the good. So there could also be situations where there is indeed a campaign organized by not independent media outlets. So this is totally imaginable, and sometimes it happens. So this is why we need a balanced approach. But let me be very clear. Slap cases are a threat, and this is why we have to tackle them. And this is why I really want to empower NGOs, right defenders, and journalists to defend their rights and to do it more easily than today.
So we're opening the floor for questions. Please ask us in Zoom. There is one question which of course has no single answer, but maybe you can elaborate a bit on that. Who is the authority in the member states that must lead the process? I mean, after we have the measures taken on European level, then which would be the relevant authorities that would have to implement these measures? Mr. Wölken, maybe again you can start.
Yes, so, okay. I hope you can hear me now.
Yeah.
So it's a directive. The member states need to implement the measures. the measures. Okay, it's a difficult word to do. I'm sorry. So, but the very first thing which needs to happen is that we see the draft or the proposal by the European Commission, and then we are working on it. So far, we only have our initiative report, which asked the Commission to come up with legislation and take into account the views of the European Parliament. So our aim is to have a coherent approach within the Union and to provide minimum standards for all SLAPP victims in Europe.
Okay, so if we don't have other questions in the chat, actually we have two of our panelists here, and Simona Veleva and Alexander Kashumov, they are legal experts. Alexander Kashumov is an attorney in law who is leading many of the defense of such lawsuits in Bulgaria. Simona Veleva is a constitutional and media freedom expert who is working with the Association of European Journalists, among many of her other endeavors. So I would like to ask you if you want to take the floor and ask some questions to our panelists, maybe, or to share your observations.
Yes, sure, of course. Hi, everyone. It's a great pleasure that we open the discussion about this topic, because so far I think many people didn't even know what SLAPP stands for. And when I was talking with different journalists, they were like, what is SLAPP? What does this even mean? So this first discussion, especially in Bulgaria, I believe is extremely important. By the way, there was a proposal for a text of the directive of a group of NGOs from 2020. And my question is towards Luise, if she's here and she can hear us. Are there any texts which are ready and the Commission is discussing? Because in this proposal, there was a whole text of a directive which was ready. The NGOs suggested this directive, and I think the most important question is not whether or not we need an anti-SLAPP legislation, however, is how to reach it and how to write it in order to make a balance. So, does the Commission work on those texts?
So this question would be for Madam Quaritsch. If you would like to answer, I also, yeah, please.
Yes, thanks for the question. We have indeed received the model directive I think you're referring to, and we're working with all kinds of inputs. We're working with an expert group, so many of the people that were in fact involved in the drafting. We're conducting stakeholder meetings. So many of the experts that have been working on that are also in contact with us and helping us shape this initiative. So yes, we're taking that into consideration.
Also, the other panelists can comment, but Alexander Kashumov has also a question or a comment for you.
Yes, thank you very much. It's really a pleasure to be here, and thank you very much for this very important discussion and very important initiative. I've been working for more than 20 years on that kind of cases together with the Access to Information program in Bulgaria. One thing I would share with regards to the question of criminal or civil defamation is that indeed it is different in the different countries, and we cannot conclude that criminal defamation is always worse than civil defamation, because we also see very problematic issues in civil defamation. And I would remind the judgment of the European Court of Human Rights on Kashumov case, where he denied to accept that criminal defamation is always against the convention. But I would like to ask, we face here a particularly harsh problem with preliminary injunctions of civil courts, which, well, what is the situation if a civil claimant starts a case for, let's say, 100,000 euro? Then they ask the court for a preliminary injunction, and then the court freezes the property and the bank accounts of a small internet media, which actually could kill it, because then the civil defamation lawsuit will last for the next 4 or 5 years. So do you think that this should be covered also by the EU legislation, and do you intend this to be regulated?
I think we can include all the participants. Let's start with the European Commission again, then Mr. Wölken, and Julie and Jessica after. Ms. Quaritch.
Yeah, sorry, could you restate the question? I'm not quite sure I got it.
Yeah, preliminary injunctions imposed by civil courts with the result to freeze bank accounts of media. And this could affect bank accounts with amount of 100,000 euro, which is killing for a media enterprise, a small media that maintains a website.
Yes, as I mentioned, we're looking at procedural safeguards in this upcoming directive. I'm not quite sure what the exact elements will be. As I said, we're in the evidence gathering stage, so those are all elements that are being considered, but so far there's no those specific elements I can speak to yet.
And Mr. Wölken, are you aware of this issue, or maybe in your research phase did it exist in some other countries? Because in Bulgaria it indeed is an issue. Basically, during these lawsuits, you have all your assets frozen as a media, sometimes as an individual. So basically, you're killed for 5 years without even being proven as guilty. And most probably, you will not be proven as guilty.
Yeah, thank you very much for bringing this up. So, yeah, we, of course, so I wasn't aware of a case in Bulgaria, so that's good that we know now, and we will definitely keep this in mind. But for example, there have been, let me use Daphne Caruana Galizia again as an example, the journalist from Malta who was killed. And yeah, she had, as was rightly said, 47 or 46 lawsuits against her pending, and her assets have been frozen too. So we have been aware of such cases. So the prospect of having the assets frozen can indeed, and this has also been worked out carved out very clearly today, can have a chilling effect. So keeping journalists, academics, right activists, indeed away from doing their job. And this is, of course, exactly what claimants want. And others will fear these lawsuits. So this should also be addressed. I think we are calling for very early dismissal opinion, and this should also be, from my understanding, be possible for preliminary injunctions, bringing the defendant and the claimant on equal footing. And this is what it's all about, giving all the same rights and not having an imbalance of powers.
Thank you very much. And maybe some last words for this part of our conversation. Of course, you are more than welcome to remain and to listen to the Bulgarian part, because I think it would be also for your research phase. But Julie from Reporters Without Borders, if you want to say something in conclusion.
Yes, I mean, just to answer this question and to add a bit on what Tiemo Wölken said, I think that the key element of EU legislation would be this early dismissal mechanism. And this mechanism means that the judge will have to examine the merit of the cases and decide in an early stage to reject it or not. And during this early dismissal mechanism, I think that everything else, like in this preliminary injunction, would be freeze. That's part of what we are proposing in the model directive. So, and it's an incitation, you know, to fight this willing of the plaintiff to have this suits going on and on. But if everything is freeze until the early dismissal mechanism is at the end, then is finished. I mean, then it will be, you know, a way to make these lawsuits a lot shorter and to freeze everything else in between. So yes, I think that's the way the EU legislation should work.
We really hope to see those changes, because this would really solve a big part of the problem at a very early stage as it exists now. And Jessica, some last words from you.
I think there's so much more that could be said, and I'm not going to take up too much time. Maybe I can close with a quote from Donald Trump, which I think summarizes the problem of slaps quite well. He has been practically an advertisement for slaps, and I think it explains maybe why some of, I think, the political followers or political politicians in Europe who admire Donald Trump might be using slaps as well some more. So here's the quote. It was him commenting on a slap he filed against a journalist a few years ago, and he said, "I spent a few bucks on legal fees. They spent a whole lot more. I did it to make his life miserable, which I'm happy about." That's it. Thanks a lot.
Thank you very much. Thanks a lot to our panelists for taking part in this discussion, which is really, I believe, the first one on the topic in such a form in Bulgaria. So thank you for joining in. We would need 1 or 2 minutes to technically arrange the next panel. Имаме нужда от 1 или 2 минути ще направим съвсем кратка пауза, за технически промени за вторият панел с нашите български участници. Отново каним.
So again, all international panelists are invited to stay until the end of the discussion and hear something about the Bulgarian situation. Thank you very much.
И ето ни отново в...
Let's proceed with the discussion that is dedicated to the undue use of judicial actions against journalists and activists. The first panel was dedicated to the European framework regarding protection of journalists and civil activists against lapse. And we had 4 panelists, members of European Commission, European Parliament, Reporters Without Borders, and the Index of Censorship. So now we are going to move on to the protection of journalists and civil activists in Bulgaria. So for this conversation and discussion, we have invited Alexander Kashumov, head of the legal team of Access to Information program. Next to me, I have Simona Veleva, media law expert, and we'll have Rosen Bosev. Hello. And Regina Stoilova, a lawyer. She represents Greenpeace Bulgaria. I mentioned several times that this is not a topic that is addressed only to journalists. It's somehow, however, journalists are more visible, but this slaps refer to activists as well. So, Mr. Kashumov has over 20 years of experience in litigations. Obviously, the problem of SLAP has not bypassed Bulgaria. And we know that the Bulgarian journalists and media, on the one hand, turn out to be an extremely important factor, and the better part of them perform their duties with due diligence. Journalists are one of the main users of the provisions of the law for access to information. However, there are numerous challenges and difficulties faced by individuals regarding their protection against defamation reports. Let's start with the bad side of the situation in Bulgaria. We heard about this journalist in Portugal that was sued for lots of money. The same happens in Bulgaria. One of the largest company dealing in the stock exchange has filed a lawsuit against a journalist, against the Bivol website, which is investigative journalist website, for over 1 million BGN. And the entire lawsuit is about lost benefits, missed benefits, and losses. So from there, I want to move on to another case against a Varna businessman who is owner of a bank in Malta, and he's suing a Maltese journalist who published details of the status of this bank. And as a result, the relevant institution in Malta have undertaken the proper actions, the relevant actions. But we have But the journalist was sued nonetheless, even though the Bulgarian court dismissed the case. So this is some new aspects of the Bulgarian reality. I am happy, though, that the Bulgarian judicial system has the capacity to tackle issues like that. However, I cannot withhold my concerns regarding the criminal defamation that was prosecuted, and a friend of mine, a journalist, was actually sentenced. There are some sectors that hold industrial sectors that hold priority in slabs. Energy, for instance. Mr. Hristo Kovački, in the role of a plaintiff, has filed numerous lawsuits for publications and media comments. We had some weapon boss of a weapon company. Also, Maria Chereshova was directly involved in a case. There was a very interesting publication about the road of a machine gun from Serbia through the Balkans going to the Middle East, Syria, namely. And the case of Veselin Mariški, who is not only a businessman, but also a member of Bulgarian parliament, and in fact deputy speaker of parliament. He filed a lawsuit against Valia Akhchieva. Stoyan Mavrodiev is yet another name associated with lawsuits again against media and journalists. We have current criminal proceedings against Nikolai Stoyanov. If we want to recall some older cases, when Nikolai Stoyanov was head of the Financial Supervision Commission, the Commission independently and imposed very serious sanctions on media. I hope that my words won't give rise to a slap against me. I just need to mention that there are numerous institutions apart from the court that are involved. For instance, the Bulgarian National Bank, the Commission on Protection of Data Privacy, the Commission of Financial Supervision, the Commission on financial issues also. There was a very interesting case that was under the penal code. Since we discussed the European framework and the commitment of the European Union, I believe that this commitment is a bit delayed, but I'm very happy that we have this initiative underway, simply because of media, journalists, the leaders, the lawyers, we should have taken proper position in order to make things move forward. When GDPR was adopted without considering the balance, in Bulgaria, we had a very interesting constitutional court back in 2015. When we consider the protection of financial markets from abuse, then we need to mind all the publications, because they open a room for slaps, could be used for slaps. We also needed to look for a balance, because sometimes the heads of media outlets are subject to threats. Media pool is another interesting case, together with the media outlet, with the the journalist in person, and the entire team that worked there. When they published the procedure that involved the election of the chairperson of the Sofia City Court. A case was filed, but for 18 months now, there are numerous collaterals imposed. I'm talking about injunctions, and the amount are above 150,000 BG, and then the Court of Cassation reduced them to 60,000, and this is the final amount, if I know correctly. Then another asset freeze was imposed on Capital newspaper, but this went for years, and the journalists couldn't use these funds. For the chief editor, this is a very serious burden. We're talking about professionals here that cannot do their job professionally. Thank you very much for all the details that have demonstrated the burden of slaps. I'm happy to hear that the judicial system in Bulgaria works towards protecting democracy and freedom. Let me address now Rosen Bosev.
So I hope we understood what slabs are, but what is the effect on a journalist who is litigated against, both in professional and personal context, having in mind that what the goal is intimidation and pressure. Thank you very much, Maria. Well, It is, to put it mildly, it is annoying to know that you are a defendant. For years, I covered the work of the courts, and I've done everything possible to uncover any attempts of other authorities to be accomplices in somehow, and ultimately I became a victim of that. As a journalist, being journalists, we often have to resort back to publications of years ago. Sometimes there are tiny details and facts that we tend to forget. We prepare for a court hearing in details, then we again go back to this past court hearing, and this is difficult in our work. But what is important about SLAPS is the inequality of parties, because anyone can actually instigate proceedings against a journalist. The only thing they have to do is find a lawyer, spend 20 minutes on the claim, and that's it. On the other hand, we as journalists have to devote months to this. Many lawyers work pro bono, and we as journalists have to stand by their side and help them with information gathering. And usually a claimant sends out his or her secretary to pay the fees and deal with details. So it is, as a minimum, it is annoying, I would say, to be involved in a SLAP. And also, if you have the whole state using its repression arrangements against you, it's a real pressure. It was mentioned that usually this is the tip of the iceberg. Once other forms of intimidation are used, then a lawsuit is taken up in order to intimidate further. Yes, this is true. What I have often seen in lawsuits against media outlets and journalists is that this is used by one of the party as a form of demonstration. They don't give a damn that the lawsuit may be dismissed not to their benefit. Even if this lawsuit is lost, this wouldn't cost them anything in professional terms. So why not waste the time of a journalist and stress him or her out? Yes, to one of the parties involved, this is a matter of minutes, and to the other, a matter of years. I will address Regina Stoilova, lawyer. As we mentioned, NGOs, civil society organizations are also litigated against in order to demonstrate power in court. This is also valid for environmental organizations because they affect interests, usually corporate interests. In 2017, the Clean Air Group filed a lawsuit against the metropolitan municipality that was won by the civil society organization, which is, by the way, part of Greenpeace. And the Metropolitan Sofia municipality will be forced in a matter of days to take measures against the polluted air. The lawyer's fee that the Sofia municipality paid to its lawyer amounted to something like 100,000 levs. So if your organization happened to lose the case, this would be a heavy financial burden on your organization. Could you please elaborate on that and also on other examples? Yes, this was the fee paid to the lawyer of Sofia municipality, 108,000 levs. So this lawsuit involved not only our organization but other organizations, which meant that if we lost the case, we would have borne the financial burden equally. So we saw how this could be used as a silencing method. What was peculiar about this case was that this was a successful lawsuit against Sofia municipality, and at first instance the court decided that Sofia citizens should enjoy adequate measures against the polluted air in the capital city. There was a similar law case in Plovdiv, a large city in Bulgaria. After 10 years of fighting, there was a positive decision by the court to the favor of the citizens. What we see here is a tiny detail which is still very important, because all of us who work in the environmental field face this obstacle, this method to put pressure. So on the one hand, we have environmental activists who are the subject of a typical slap procedure. There are often smearing campaigns being carried out against non-independent media. So environmental activists are often the object of this type of silencing attempts. And I guess they often go hand in hand. Yes. So what we see are that such lawsuits are being brought up by activists or regular citizens, but as a mechanism to exercise a right. In this case, the right to breathe clean air. So this is, they seek a way to prevent potential big pollution. For example, this is the pending case against the incinerating facility in Sofia. So one of the parties involved was requested to pay lawyers' fees to the amount of 50,000 levs. So sometimes the claim involves fees which are disproportionately huge, and plaintiffs could be sometimes physical persons or NGOs which often lack such financial resources. But the very fact that such cases are on the rise, and we witness them more often, even by state authorities, means that this is a huge finger pointed at the NGOs, so that they think twice before they seek exercise of their rights, for example, the right to clean air. We shouldn't forget that sometimes these lawsuits involve common rights, not individual rights, because the right to clean air, clean water, lack of noise pollution, and so on are common rights or public rights, or the right to prevent industrial pollution. So they could involve harassment to whole communities. So environmental lawsuits are the only mechanism for these individuals to fight for their rights. And if these rights are being silenced, then we are faced with the issue of justice. Another interesting point is that with these lawsuits, we have an international framework. We have the relevant Hague Convention, which envisages that the environmental procedures must not be disproportionately expensive. In Bulgaria, this is not subject of transposition in our legislation. And we have tried to raise this issue in the court about the disproportionate fees. And not a single judge has based himself or herself on this convention. And the common principle of fees is not being used, so we don't have safeguards about what the exact decision of the judge would be. We have a pending case about 10,000 levs of lawyers' fees, which is a burden. Not to mention a local activist who decided to bring a lawsuit as a physical person against his or her municipality about air pollution. Yes, indeed, things seem to be reversed in this case. The environmental organization is considering rather it should take up any action against an authority possessing huge resources. So, Simona, I will address you now, raising the issue of whether the subject matter is familiar or not, and whether new legislation should be introduced in Bulgaria to change the rules of the game.
This is not a new problem, and the majority of active NGOs, civil society, journalists, not only EU member states, but other states have faced this problem. That's why in the US we have an anti-SLAPP legislation, and it's a working legislation. I am part of a digital freedom fund that finances journalists, activists, and NGOs when there are lawsuits against them. And with this fund, we cover the costs, litigation costs. It is an international organization. You can go to the website and see how it works. I'm one of the legal advisors that reviews the applications submitted. But this fund is designated to finance such a lawsuit. With respect to the SLAPP legislation and what we heard in the first panel, I believe that the European response is a positive first step. However, then we will see how this we will see how it is transposed and what would be the standards set out in it. Last year, a number of NGOs evoked Article 19 of the Human Rights Declaration. So they have launched an initiative that contains numerous interesting ideas and notions, but we always need to mind the balance, the need to strike balance. The directive envisages to have 3 months as a period from filing and having the first hearing. This is a very good recommendation. I'm not sure in the Bulgarian context this would be possible. This is a very short time frame. But Mr. Kashumov can also tell us how long these court cases go for. If I understand correctly, it is about a proposal. If you claim, if the defendant states that this is a slap case, then if there are prerequisites to consider it as a slap, or there are some elements pertaining to slap, then on these grounds, then the court may dismiss the case. And then to reverse the burden of proof. In other words, for the plaintiff, the burden of proof to lay with the plaintiff. This is a very good idea, but just like any other good idea, it is about practical application. As mentioned earlier, it is important this anti-slap legislation can be properly applied. At international level, I see that there is a will to amend the legal provisions. That's why the directive that has already been adopted and been transposed in Bulgaria, it's the so-called whistleblower directive. So an anti-slap legislation is totally feasible, but it should go hand in hand with the proper measures. And in Bulgarian context, I believe the legislation should encompass also some other aspects, for instance, state funding of media, also registries, for instance, the media register that is under the Ministry of Culture is not regularly updated, and information is not cannot be considered reliable. So, in that sense, the media that are state-funded should be allowed to defend themselves when threatened. We have witnessed many situations when goodwill notions are actually ending in some different outcome. So, what would you say, sir? Of course, there are traps on the road to proper devised legislation. The European legal document, an instrument, should be consulted widely, broadly. And also, something has to be accounted for. For instance, North Europe, there is a very strong understanding and perception of freedom of speech, while to the south of EU, things look different. The next aspect refers to transposing the EU directive, and I wonder what the national parliament will do. My impression is that sometimes the Bulgarian parliament is coming up with initiatives to stop rather than to promote the implementation and transposition of a certain directive. And the third thing I need to mention is that when you are putting regulations in place, you need to think about even commas. Freedom of speech in Bulgaria is something that is not highly regulated in Bulgaria. In the transition period, many people spoke about imposing stricter regulation to the media, but we don't have such legislation. However, some regulations, as mentioned by Simona, we have something. We have some elements that are not properly implemented. For instance, the earlier mentioned media register with the Ministry of Culture. Public financing of media is not something awkward. There are so many details that need to be considered. For instance, media is considered publicly funded, but a declaration of annual return declaration is lodged, and it turns out that it's not a public media, it's a private media. So the duration of such slap lawsuits need to be understood well. The measures and proposals heard by NGOs deal a lot with the solidarity issue. Very frequently, journalists feel alone. They don't want to bother anyone else with their issues, especially when we're talking about small and independent media outlets. The situation gets more complex. Rosen, your lawsuit has been heard broadly, even in Strasbourg. What is the importance of these solidarity measures when we're talking about pressure and intimidation? I don't believe that being noisy can help a journalist that is a defendant in a case. I believe that it is important for more judges to realize the importance of SLAP lawsuits. But definitely, we need to join efforts as journalists in order to support ourselves. As for the lawyer for the defense, it is important to be well prepared. Bulgarian courts are not very open to applying the rulings of the European Court of Justice. Back in 2001, we started talking about the practices under the Human Rights Convention. I remember the Prime Minister at that time, Lyuben discussed this issue. There were two Bulgarian journalists that were defendants, and at that time, I remember the judge quoting the ruling of the European Court. But I'm aware that there are judges that don't want to use some standards. And I suppose that the reason is mainly to the fact that they have not witnessed a truly jeopardized SLAP lawsuit. I hope that two things are important. First of all, the public awareness campaign on the importance of freedom of speech. And secondly, those that in fact stand behind such a campaign should stick together. SLAP cases should be heard by society. And third, there should be mechanisms put in place regarding self-regulation, because when we talk about state repression, we need to oppose it with our ethical rules and norms. And I believe ethic aspects will hold even higher importance than today. Now I urge you, if you have more questions or anything else that you want to raise as a comment, use the hand function for raise your hand, the function offered by Zoom or the Facebook, write in your Facebook. When we started discussing SLAPs, and the expectations of EU legislation, then it happened that people started talking about the lawsuits.
Regina, there have been cases of lawsuits against activists. You told us about the usual mechanism of very expensive litigation, but what about activists? Are they subject of potential attacks? Do they feel this way? Yes, this is so. I mentioned the cases of smearing campaigns. This is the most common mechanism. There was this outrageous example under which we addressed a UN body for protection of the access to justice. So in this case, there were people in power who mentioned very negative things about green activists. Some members of parliament called such activists green sweat, and there was a MEP, green MEP, who was publicly insulted in Bulgaria. So these are ways to silence and restrict the activity of those activists by personal attacks. There were activists from different media outlets who were subjected to violation of their privacy, and there were attacks against them with fake facts. So this smearing campaign is very unpleasant. And I guess those activists use their right to file a lawsuit for libel. So this is not an issue that has one side only. And this is visible in other countries too, not only Bulgaria, but also other Eastern countries. Yes, we try to use this mechanism via going through this UN body committee, using the grounds of attacks against activists. So similar to journalists, activists also protect the common good. And when they exercise their activities, they shouldn't be subjected to attacks. This case is still pending, and it will be interesting to see what the UN committee will have to say, because that authority has rarely voiced its opinion on those issues about asset freezing of green organizations or closing down environmental organizations. So our Bulgarian case could become part of the mechanisms of protection. So there are no further questions, so I would invite you to say concluding words. What we understood is that this issue is not entirely in the field of court litigation only. There are also other realms that are applicable. Yes, indeed, we can say that we have two competing rights or goods. On the one hand, we have the right to free speech, and on the other hand, the right to reputation, to having one's name good. So both rights must be defended, must be protected, which constitutes a third right. But how we find the balance is the big question, in my opinion. And this is something we'll have to answer, that we have yet to answer and achieve this balance. I think that anti-SLAPP legislation is indeed needed, and there must be a mechanism of early dismissal, so that courts can terminate quickly proceedings against media outlets and journalists. There should be balance of the parties. And also a very detailed regulation is needed of all local problems we have. One of them has to do with funding of media outlets by the state budget. So this also should be tackled in order to find adequate solutions. Yes, indeed, this is an entirely different topic. I hope that we'll be able to have a discussion on this topic later. Lawyer Kashumov. Well, it seems to me that yes, definitely such safeguards must be present, and they have to do with the freedom of speech. What Regina mentioned is right. Not only journalists are subjects of such lawsuits and restrictions and injunctions. There was this activist who voiced his discontent against Biljana Petrova and ex-mayor Ivancheva during a court hearing. Then a lawsuit about hooliganism was filed, and the defendant was acquitted. But this shows that bodies such as the prosecutor's office are ready to set the state machinery in motion to exercise pressure and silence entities. Boyko Atanasov, prosecutor Boyko ex-prosecutor Boyko Atanasov allowed himself to criticize publicly the work of the incumbent prosecutor, and then the logical consequences followed. But I believe that it is up to the court system indeed, because all lawsuits end up with the courts. And we need a wider understanding of the notion of freedom of speech. As the Human Rights Court has pronounced itself, this presupposes tolerance to the voicing of different statements and different opinions. Thank you very much. Obviously, we have a long road to walk, but still with moderate optimism, we accept all your opinions, also everything that was mentioned by the foreign representatives. Thank you once again. Everything that will be done by the European Commission will be something that has been discussed, but it will take a new form, a regulated form. So thank you very much.